Grace, do you have any questions out there that you've been able to get that you want to get for us?
Yes, sir.
All right, let's see what you got.
Okay, this is from Maria G. She said, or she's asking, I have an approved I-601A waiver. Did I correctly answer no on my DS-260 about 1 year of unlawful presence, or should I ask the NVC to unlock my phone? Maria G from Austin, Texas.
All right, Samuel, put it up. That is also a very important question because, again, is why I say it looks like just filling a form when you apply for these visas. But one little question can end up ruining your American dream for a very long time, if not forever. One of such is this type of question that Maria is asking. Now, Maria, I hope you are listening out there because they got this from what you sent to us. This question requires careful review because two DS-260 questions ask about different issues. They ask one question one way, then they ask it a whole different way in another part of the form. So if you enter the US without inspection and you remain there continuously, you may have accrued unlawful presence. In other words, if your initial visa had expired and you continue to stay here. So an approved I-601A, that one, there are two types of 601. There is a 601A, which is a provisional unlawful presence waiver. That one is only used to waive unlawful presence. Let's say your visa expired in June and you stayed here till October, or you stay here till January, more than 6 months, but less than a year, or you stay there more than a year. Okay, you use the 601A to waive that unlawful presence for you. That form, 601A, I-601A, waives unlawful presence on certain grounds, but does not change, and I want you to listen to me carefully here, it does not change the underlying facts. The underlying facts are about your immigration history. So whether no was the correct answer depends on the exact wording of the DS-260 question you're answering. That 2 or 3 of them that relates to this type of question. So I don't know the one you're talking about. So whether you answer no depends on the exact wording of the DS-260 question and how your period of unlawful presence is calculated under immigration law. Because if you have been in this country illegally for more than 6 months, but less than 1 year, it's a 3-year bar if you go outside the country. If you have been here unlawfully for more than a year, then it's a 10-year bar when you leave the country. So when you're trying to waive it, it depends on which one you fall onto. So it is generally better to correct it before your immigrant interview than to leave incorrect information in the form if you have already answered it. You want to check it out and make sure you correct it before the interview starts, because once they start, they typically will ask you even to sign that interview and that form. Once you sign, you are saying everything there is correct. And at that point, it's too late. So what you may also do, and I think you got that last part of your question correct, you may request that the National Visa Center should unlock your DS-260 if a correction is necessary. In other words, if you made a mistake on your form, they can unlock it for you. It's happened to me a couple of times. I had a client who's from Nigeria, but the child was born in South Africa. He had 4 kids. Somehow, looking at the birth certificates of all the 4 kids, and by the time I got to the 4th kid, I just assumed she's also Nigerian, which is why you never assume. So when I fill the DS-260, I just put every one of the children as from Nigeria, as born in Nigeria. But one was born in South Africa. Luckily for me, after I had submitted, the next day, when I got the appointment interviews for them, luckily the father was diligent. He saw that I made a mistake by putting Nigeria for the 4th child. And I had to go and tell them to unlock the form. There's a place to do it on their website to unlock the form so that you can fix the problem before the interview. So yes, you actually can absolutely do that. for them to unlock the form for you so that you can fix it if necessary. But before doing so, again, I'll be like a broken record tonight. Consult your immigration attorney. If you don't have one, go get one. Especially since you have an approved I-601A waiver. You say you already have one. Since you have one, it's not an easy thing to just say, go there and start filling form and be answering yes or no to stuff you don't even understand. Some of those questions are counterintuitive to common English sense. I know because I fill these forms all the time. Accuracy and consistency are critical to avoid delays or questions during consular processing, especially when you're from one of those countries where they really suspect a lot of fraud. So that even when you're not doing fraud, they already assume it's fraud you are doing. Just because you answer the no, yes, or you answer yes, no. Hopefully, a word is enough for the wise. This season, they can hold your application there for the next 2-3 years just because you answered wrong. So if you know that you have answered incorrectly, a good move might be to get NVC, the National Visa Center, go to their site, tell them to unlock your application and then fix the problem. But I'm recommending that before you do it, before you even ask them to unlock or not unlock, talk to a qualified attorney, let them give you it's just consultation. After they explain to you, then you can go back and go do what you got to do. You don't have to pay thousands of dollars for the lawyer if you don't think you want to hire a lawyer at this time. But getting an opinion of a legal counsel helps you to save problem down the road. All right, Maria, I hope that answers the question.